Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to a special edition of Our Curious Amalgam. My name is John Roberti, and today we have a special panel discussion on AMG v. FTC, Supreme Court case considering the scope of the FTC's enforcement authority. And with me today is Honora Wang. Hi, Honora.
Hi, John.
Honora, what are we doing today?
We actually have a very interesting and important panel of speakers who are going to discuss the oral arguments in that case and also its impact in FTC's authority under Section 13B of the FTC Act.
Now, 13B of the FTC Act is a provision that allows the FTC, or at least the FTC's interpretation, has allowed the FTC to seek what's called disgorgement. It's the return of ill-gotten gains from various, fraudulent or anti-competitive conduct. It's been a staple for FTC cases going back 40 years, and is much more frequently seen in consumer protection cases, but also has been seen in competition cases. And what the case in the Supreme Court questions is whether the FTC has ever had that authority and whether there is authority to seek this type of remedy at all.
Yeah, I agree. I think that section, as you said, ever since being written into the FTC Act in 1973, has become an important tool for the FTC to use to freeze assets in both consumer protection and antitrust cases. And its use in antitrust cases has been more recent and controversial. And this is really important because legally there is now a circuit split with the Seventh Circuit disagreeing with several others, including notably the Ninth Circuit, on whether the FTC's 13B authority provided for monetary damages because, there's a strong textual argument that it does not. And practically because that section has been relied on for the FTC to pursue remedies especially in the CP space with fraud cases and now more and more in antitrust cases. If the Supreme Court says no, the strong textual argument prevails, then what does the FTC do? Is it going to ask Congress for reauthorization or clarification that it does? So this is huge on so many levels.
Okay, we have a tremendous panel. Gerald Stein, one of our leaders in the antitrust law section, is going to moderate a panel, and he's with the panelists. Gerald, take it away.
Hi, my name is Gerald Stein. I am a partner in the Antitrust and Competition Group at Norton Fulbright, and I am delighted to present today's podcast. We have four outstanding speakers who are going to comment on the oral argument in the AMG versus FTC matter, which was argued on Wednesday, January 13th. And we're going to get into the discussion of the oral argument as well as some of the predictions and policy that each of these speakers brings to the table. Michael Kades is the Director for Markets and Competition Policy at the Washington Center for Equitable Growth. His research focuses on competition and antitrust enforcement with an emphasis on consumers, wages, equality, and innovation. Prior to joining Equitable Growth, Michael worked as an antitrust counsel for Senator Amy Klobuchar, who is the ranking member on the Senate Judiciary Committee on Antitrust, Competition Policy, and Consumer Rights. Previously, Michael spent 20 years investigating and litigating some of the most significant antitrust actions as an attorney at the Federal Trade Commission. Tim Muris is a senior counsel at Sidley Austin and the foundation professor at the Scalia Law School at George Mason University. Most of you know Tim as a longtime member of this section and as an antitrust chair earlier in the century. What you may not know is that Tim is the only person ever to be the director of both FTC enforcement bureaus, and it is in that role that he is especially important today. As director of the Bureau of Consumer Protection in the Reagan administration, Tim was instrumental in starting the FTC's fraud program using 13B as against fraudsters to obtain ex parte asset freezes and return money to consumers. He has written widely on the subject, including an article in the latest antitrust source rejecting the positions of both parties in the current Supreme Court case and calling for a middle ground position on the use of 13B. Maureen Ohlhausen chairs the antitrust group at Baker Botts, where she focuses on competition, privacy, and regulatory issues, and frequently represents clients in the tech, life sciences, energy, and retail industries. Maureen served as acting chairman at the Federal Trade Commission from January 2017 to May 2018, and as a commissioner starting in 2012. She's received numerous awards, including the FTC's Robert Potofsky Lifetime Achievement Award. Maureen clerked at the U.S. Court of Appeals for the D.C. Circuit and received her J.D. with distinction from the George Mason University School of Law and her B.A. with honors from the University of Virginia. John Villafranco is a partner at Kelly Dry & Warren. John represents clients in investigations and litigation brought by the FTC and state attorneys general involving advertising and marketing. He has written extensively about the 13B issue and is widely considered one of the nation's top consumer protection lawyers. So this is an esteemed panel, and thank you all very much for your time today in discussing the oral argument in the AMG versus FTC matter. So let's turn to your thoughts on the oral argument, and we'll give everyone a turn to express, things that surprised them, things that didn't surprise them, some questions that were raised. Maureen, if you don't mind, let's start with you and get some of your thoughts on that.
Well, thanks, Gerald. Thanks to everyone. I'm delighted to be here and to participate. 13B and disgorgement and redress have been some issues that I've tried to pay a lot of attention to while I was at the commission and subsequently. I wouldn't say anything really surprised me in the oral argument. I think the issues were pretty clearly delineated. Though one of the things that at least I found amusing right off the bat is when Chief Justice Roberts asked about whether they should interpret the term injunction based on the freewheeling nature of interpretation at the time. It kind of reminded me of like an Austin Powers type of like it was the 60s baby. And I didn't feel that was much. I mean, to the extent that there's not a great fondness to rely on legislative history to then go to something that's even less concrete than legislative history, I think was not particularly, I'm not sure that was reflective of where he will eventually end up. I did think, importantly, there was a lot of focus, not just on the limited words in 13B, but the overall structure of the statute and the role of the FTC. And some of the issues I really appreciated, it was when Justice Breyer and Justice Gorsuch tried to look at that bigger picture of what was the FTC created to do, what tools was it given in light of kind of the generality of the statute that it had, and where did Congress give it certain authority? Because I often think some of this discussion kind of devolves down into, do you think the FTC should have this authority? And if you think you should have this authority, it has this authority, rather than saying, should it have this authority, but did Congress actually give it to it? So I do think that the discussion at the oral argument the other day did an admirable job of kind of, I think, driving to that key issue.
Tim, would you like to go next and just give some of your thoughts and comments on the oral argument?
Sure. A couple of comments. This was a tough case in one sense, as you'll see in terms of my views. The court was not well served by the arguments of either party. And I'm sure we'll talk about that at length. That's the first comment. A second comment is I think most people believed, and I agree, that it obviously is hard to read something from an oral argument, and this is a new structure of oral argument, and we don't have a lot of history interpreting it with the structure in the pandemic. But I do think, reading the tea leaves, it's hard to believe the FTC's position of it being able to always obtain monetary relief under 13B will prevail unscathed. But a third comment is, and this has not been mentioned in the Monday morning quarterbacking. One of the main arguments of the position that you can never use 13B was based on the simple textual injunction means injunction, and if you don't say injunction plus equitable relief, then you can't get plus other equitable relief, then you can't get money. That argument was not the argument that that the justices were using to criticize the FTC. It was much more the structural nature of the FTC statutes, a point that Maureen made. So I think on balance, I wouldn't be surprised if the FTC doesn't prevail, but I would also not be surprised if the defense doesn't prevail entirely either.
Okay. All right. Thank you. And Michael, any follow-up?
Well, it's pretty hard to follow up on two former FTC chairs.
I should have reversed the order. Sorry.
Well, no, I'd rather be able to be commenting on them rather than having them being able to critique me. I had enough of that in oral arguments. No, I would say, I'm going to deflect a little bit here and say what's been most surprising to me was the press coverage has been very, so sort of negative to the FTC. And maybe this was just low expectations. I thought just where this court was generally, the FTC was going to get hammered. I didn't really think that's what happened. I'm not saying, I wouldn't dare to predict what was going to happen. But I did think, I was surprised that Alito was interested, although maybe the chief was being a little tongue in cheek about thinking about how the statute was originally interpreted. I took Alito's question about Black's Law Dictionary to be, and sort of giving some credence to that. Not that that's where he's going to end up. I thought Justice Gorsuch's questions about the line drawing I took to be, again, not necessarily outcome determinative, but interested in that, it's a less hostile approach to or suggesting that the issue is a little more complicated than when I would have suggested. The other sort of bizarre part of this argument, and here my ideological bias is going to come through, but for a court that is claiming to be textualist, and particularly Justice Kavanaugh and Justice Alito, to spend as much time as they did on statements from someone who was a staff attorney at the FTC in the 70s and the 80s was, I just think, bizarre, was not consistent with their judicial philosophy, and I think really undermines the integrity of their position. I mean, if we're going to be textualists, then we need to be textualists, and it's not a matter of picking and choosing when you're going to go outside the text of the statute to sort of argue. But so that was sort of my reactions.
Okay. And John, you want to round it out?
Sure. I guess my view is a little bit more consistent with the press reports. I mean, I read this SCOTUS blog, for example, which I think is reputable and usually demonstrates a good deal of restraint. And, in the post yesterday, they wrote that they considered the case one of the simplest cases that the court would hear all year, and that the reading of the argument is really whether, in their opinion, whether AMG will be the first opinion from the January argument calendar, or whether the justices, and I think what they said was, will find some other case that may seem even more obvious to them. I mean, that is a pretty scathing report from that blog, which again I think shows a good deal of restraint. And Kavanaugh, and I wrote about it, and I thought that the line of the entire argument that really resonated the most was when Kavanaugh said, I think the problem that you have is the text. And then, he focused on separation of powers. And then he was almost like a comforting parent when he said, I get it. I was in the executive branch. I understand you want to do good things and prevent or punish bad things, and sometimes your statutory authority is borderline, and with good intentions, the agency pushes the envelope. And I think that really captured where I think this court is. In terms of some surprises, I thought that Justice Barrett's and Alito's fixation on Tucker kind of surprised me. I mean, he is not a sympathetic character by any means, and I think it would be hard to argue with. I mean, it totally seems unfair that he actually might get a pass on dollars, but I don't see how that had anything to do with the scope issue here. And I was pretty surprised that they burned as much time on that point, on a point that really I didn't think was very relevant. And then finally, or two quick things. I absolutely agree. I was surprised at the conversation about Mr. Fitzgerald, and then I think that Joel Marcus was just wrong when he was asked about the viability of Part 3. And I know, Maureen, you've written about this. I mean, there's just been a complete retreat from Part 3. From the period. The last 10 years compared to the prior 10 years. I mean, there have been, I think, 9 cases that have been brought under Part 3 in the 10-year period, 2016 to 2009 or so, or 2008. So I was I don't think that Joel answered that question correctly. I think that he was actually wrong about that, and that kind of surprised me.
So let's turn to that, because I think it's interesting to note the different time periods of the history of the statute, and we note that the statute, the statutory authority here went under some changes in the period of 1976, 77, when these statutes were being amended, and the FTC came out with guidance when Tim was chair of the FTC back in 2003. The FTC actually issued guidance on when the FTC was going to use these different remedies. That guidance ended up getting withdrawn in 2012, and I think we can see the difference in the types of cases, or the number of cases that were being brought prior to the issuance of the guidance, and then during the guidance, and then after the guidance. And I think that's what you hit on a little bit there, John. And Maureen and Tim, I don't know if you want to comment on that.
Sure. So you're exactly right, Gerald, to focus on that. I objected to the rescission of the disgorgement policy statement in 2012. We essentially took away any guidance on when the commission would be using it. And previously, it had to be a clear violation. You had to be able to assess, what the disgorgement amount should be, and that there weren't other remedies available, right? And so, kind of toss that aside. And it was supposed to be for extraordinary cases. And then it continued to get used more and more. And I think the court really picked up on that when they were saying, why would you ever use anything else, right? Once you've had this immensely powerful tool, an easy path, why would you do those other things? And so one of my concerns at the time at the commission is I often push back on this idea, because I gave a speech that kind of summed this all up called Dollars, Doctrine, and Damage Control. That talked about disgorgement and the idea that it was causing the FTC to bring a lot of cases into federal court so it could get this money, and neglect using Part 3 as a way to develop. I was talking about antitrust case law, but it same really applies, I think, for complex consumer protection matters as well. And so when Justice Breyer was mentioning the Cardinal case, and he mentioned that several times, that's a case in which I issued a dissent saying this was not an appropriate case. It wasn't a clear violation. The amount was not easy to calculate, and it shouldn't have been used. And one of the issues that I had tried to emphasize over time is, look, disgorgement and this kind of redress. Yeah, the benefits of it are it can change the incentives of the actors in the marketplace, but it also changes the incentives of the enforcer. And I think the Supreme Court picked up on that, where the agency then just kind of started going down that path. And so while you may say the Fitzgerald, why were they talking about the Fitzgerald article? It certainly showed that, kind of impulse. It also gave reflection on what the agency, maybe he obviously didn't speak for the agency, but some idea of what the agency thought the boundaries of its authority were at the time. So I think that's really, really an important point in this, is that the FTC has moved away from using Part 3, and I was a fan of I think Part 3 could be improved, but I was a fan, particularly on the antitrust side, of the FTC has used Part 3 effectively to move antitrust case law forward, and actually won a lot of cases in the Supreme Court based on Part 3 decisions. And I'm concerned about the movement away from that to try to get money through disgorgement.
And Tim, I'd like you to comment on this, because you obviously have written a lot about this. You were the chair of the commission when the guidelines were issued, and you recently wrote an article in the December 2020 Antitrust Source advocating a middle ground. And I'd like to hear your views on this, especially in light of Justice Breyer's comment that he thought both sides were right. He had that comment, red brief, you're right, blue brief, you're right. And you take the polar opposite, and you say both sides were completely wrong on this. So can you talk about your position, what you advocate?
Sure. Well, look, both sides are partially right. And let me say what I should have said at the beginning. It's a pleasure to be here with three long-standing friends who have thought long and hard about the FTC. And I think we have to distinguish, in some ways, antitrust and consumer protection in some of this. Maureen was talking about antitrust in particular, and the Qualcomm case, on which Maureen and I disagreed on the substance, but I think we agree completely on the procedure, illustrates her point. It was a catastrophe, especially in retrospect, although I thought so at the time, to bring Qualcomm in federal district court. We're now faced with with some kind of Newton's law, where you had a bad district, the logic of the federal district court opinion, and an equally opposite and bad circuit court opinion. The district court opinion tried to extend Aspen. The circuit court opinion essentially said, well, we got to worry about the effect on competitors, not on consumers, where had the case stayed in at the FTC in Part 3, it turned out there would have been a reasoned 3-2 opinion supporting the case, at least based on the vote to appeal the case. So, in answer to the question and the point about consumer protection, you have to go back to where we were when we started this whole endeavor 40 years ago. And you have to go back even to early 1970s, when the ABA said the FTC ought to be concerned about consumer fraud. Well, the agency launched the decade of the 70s, which were a disaster. It didn't go after consumer fraud, but there was a good reason not to, because to go after fraudsters, you either have to take their money away or you have to put them in jail. The FTC can't put them in jail. And when we sat down in 1981 to think about this, and there's a good article in Antitrust magazine in 2004 about the history of this, we couldn't use Section 19, and we discussed that at length in this recent article, to take money away. So we turned to 13B, and it exceeded beyond our wildest dreams. Today, the FTC coordinates a worldwide attack on fraud, but it's based on the ability to surprise fraudsters tie up their assets, give them the chance to defend themselves. And if they can't defend themselves, and most of the time, almost all the time, they can't, take their money away. And that was the program that existed, that each chairman built upon, improved. And that was the state of affairs until the Obama administration, when they decided that they could use 13B everywhere. We predicted, Howard Beals and I, in an article published in the Antitrust Law Journal 8 years ago, that would lead to catastrophe, and low catastrophe is here. And rather than defend the case in the court, which they could have defended as a fraud case and said there's this narrow use for 13B, but an extremely important use, which explains all of the questions the court was asking, and I'd be happy to get into those as we go along. The commission laid itself open to the problems, but Justice Breyer explained it exactly. Reading from the same text as we had, although I think it's appropriate to say I've been a longstanding fan of Justice Breyer's. In 1980, I was in a meeting in the Reagan transition. He was confirmed in the lame duck, and the Republicans allowed him in the lame duck in 1980. This is something hard to believe in the current political climate. The Republicans allowed him to be confirmed. Jim Miller, who became chairman, was enthusiastic about him to be confirmed to the First Circuit. He was a hero in the law and economics movement. Then Professor Breyer had worked for Senator Kennedy and had convinced him in airline deregulation. He's a longstanding student of the FTC, and he understands that much of what the FTC does should be done under, at least that's what his questions seem to imply, should be done under Part 3 without monetary relief. But the fraud program cannot be done without 13B. I hope, although the FTC didn't make that point in this case, I hope that point is not lost when they come to make a decision.
And that's a good point. I want to continue that with John Villafranco. From many of the questions at oral argument centered around the FTC's use of 13B versus the Section 19, Section 5 route. And one of the concerns raised, I forget who raised it, but one of the concerns raised was notice to the public as to what type of behavior will be subject to restitution or disgorgement, and giving some sort of guidance to the public. So as someone out there who is on a daily basis counseling clients in this arena, how do you go about this at this point? Does it matter that much, or what are your feelings on the type of notice that the FTC has to give the business community?
Well, an excellent question. The Section 19, obviously, the standard is very clear. It requires dishonest and fraudulent conduct. In terms of advice to the business community right now, I think it's just hold on to your hat and see what happens. But, in terms of where things go, I want to first say that, Tim and Howard's paper, I thought, really struck an important middle ground. And it seemed to, in my mind, both acknowledge and recognize what the problem is and propose a solution. Gorsuch asked questions about Section 19 and whether, it's a plausible route. And I think, the Figge case really demonstrates why, as it stands right now, it really isn't, because, that case, from the filing of the complaint until its conclusion, it took 10 years to bring that case. 10 years. That really does not seem like a plausible way to get at fraudulent behavior and actors and redress injury to consumers that have been harmed. So that's a real problem. And I don't know that there's a great solution. Part 3, like I said, I read with interest Maureen's writing on this issue. And, when I started back in 1996, and Tim will remember, mean, I was one of my first cases was the FTC Joe Camel case, and that was a Part 3 case. And I thought to myself, I think I'm going to become a Part 3 lawyer. That's what I'm going to do. I'm going to be a lawyer who specializes in cases, administrative cases before the commission. And good thing I didn't go that route, because I would be more like the Maytag repairman right now. I wouldn't have had much to do. So, but where I do, while I think the argument really did cut the commission's way, I have a lot of sympathy for them, because I don't think that 19 is a viable way to, especially in the consumer protection context and especially in the fraud context, to really address the problem. And so, I'm not exactly sure where the way through is. And that's one reason why I think what Howard and Tim have proposed really makes a lot of sense. And what that does is, of course, you start to think about Congress and what's going to happen next, right? I mean, none of us have a crystal ball.
Yeah. If I could say one thing about 19 won't work against fraudsters, but it will work again in the case of dishonest or fraudulent conduct by a solvent business. Because if you look at a lot of cases the FTC brings some cases the FTC brings under 13B, where it alleges something that looks like conduct that would satisfy Section 19, they settle. Substituting Section 19 for Section 13 in the settlement would be easy. And if you catch a legitimate business in really bad conduct, they're likely to settle. So losing the 13B authority for that sort of really bad conduct is not going to be as big a problem as you might think. And there is a category of cases that fits there, and that's true on the antitrust side, which we can talk about as we go along as well.
Yeah, no, that's a great point. And what I wanted to do is segue to Michael and have his views on, no matter what the outcome of this case, because the Supreme Court's going to decide it one way or the other. They're not going to rewrite the statute. What do you think are the ramifications or the implications of this case vis-a-vis Congress? We're entering into an era where there seems to be bipartisan support for enhanced enforcement, certainly in the antitrust arena. And, no one is against enforcement in the consumer protection arena for true fraudsters and deceptive conduct. So do you see any implications of this case reaching Congress to clarify the import of these statutes and the FTC's ongoing enforcement abilities?
So I think thinking about Congress is just confusing and what they may or may not do. When I worked for Senator Klobuchar, there were two major legislative bills that I worked on in terms of trying to actually get passed. And the one that should have been easy, that literally there was no opposition anywhere, that we went exactly by the book of how you get a bill passed, magically died at some point at 11, sometime late in the night, and really we never got a great answer. The other bill, where there was significant opposition, eventually was passed. So, I really think knowing what happens is I don't want to. I think understanding how Congress works is far beyond my capability. What I would say is you're exactly right, Gerald. Look, there is a lot of pressure, and it's not bipartisan, that the FTC doesn't do enough, whether fair or not. And if you think about the types of things that are likely to generate interest, I think the kind of basic fraud. That's the sort of thing that people are not going to be happy to hear, that the FTC can't hold fraudsters accountable. And on the competition side, the primary, I'm not sure, this may be true entirely or almost entirely, the disgorgement is used in the prescription drug industry, which, what we now know is that, that the farmers' hold on Congress is far weaker, and, you have bipartisan support on concerns about drug pricing. So there's a lot of reason to think that this kind of a legislative change could be in the works. They've been talking about it. There's also added to that there's more general view bills that are likely to be introduced on antitrust or the FTC in general. So, I would say that there's a good chance on the Hill. A good chance means like north of 1% and south of 5%. With the I've never ever thought a bill has had more than about a 30% chance unless it's like defense authorization. So not a very, I think, helpful answer, but it's an honest one.
One question I have for Maureen is to going back to one of Tim's questions about the difference between antitrust cases and consumer protection cases, and in fact, one of the justices raised that. I think it was Justice Gorsuch raised the point that in antitrust cases there seemed to be more guidance and maybe more guardrails with respect to using 13B in antitrust cases. First of all, I want to know if you agree with that, and second of all, do you think that there ought to be different standards with respect to antitrust cases versus consumer protection cases with respect to 13B?
So the idea that there are more guardrails, I mean, I do think the antitrust cases, look, they tend to have better representation, right? They tend to have, the lawyers are more sophisticated, not always, right? And we've got, some complex consumer protection cases and, good lawyers like John, and Tim and others and get involved in them. But
waiting for that one, Maureen. I was waiting for that qualification.
So there you go. Got the plug in there. But and look, we did have the disgorgement policy statement, which was really focused on antitrust. I mean, it was rescinded, but so we did have that there. I mean, look, I agree. I think one of the challenges here is, and I agree that the fraud program has been really important, and the ability to use 13B to go into court to stop, what one might call rip and tear fraud, right? Obvious fraud, and to try to get money back to consumers, is a good thing. It's been important for the FTC. I think the hard part is, and I think Justice Kavanaugh kind of rang a distant bell about this, is when we start moving away from the FTC, which has an agency head that is not removable at will by the president, and you start giving that agency authority that looks much more like what I would call punishment authority, rather than really making people whole, like the restitution, I think you could run into delegation problem issues there. And there's not necessarily a lot of love lost for independent agencies who exist in a kind of quasi state. So I would be a little concerned about, that was one of the benefits, I think, about having these limits previously, where it was used in like clear violations, where it was giving money back to harmed consumers and not being transmuted into like, well, let's punish someone for doing so. And some of the antitrust stuff could veer into that, right? Particularly the part of the policy statement, the rescinded policy statement that talked about the ability to determine what the damages were. So I think those are some of the difficult issues, even if you try to give the FTC more power, is given its status as an independent agency with a head that you don't remove at will could run us into other problems. I have a saying, which I tried to use, particularly during my time as commissioner, is avoid doing things that unite your enemies. And what happened here is the FTC, I think, overused this tool on both the consumer protection and the competition side, because on consumer protection, they started to move away from clear injury to consumers, right? You sold me junk. You said it was gold. It wasn't. It was, aluminum foil, and I want my money back, right? to starting to use, like, I'm going to go into federal court to get money that isn't as easy to match to that injury to consumer. So I think that was one of the overuses of it on that side and the competition side that kind of brought these factors together to be where we are now.
So can I just say,
Michael wants to say something.
I should say, and I'm not an expert on the consumer protection side, so I'm not going to say anything on that. I know, Maureen, you dissented in Cardinal, but I have, and Qualcomm was not a money case. It's not a disgorgement case. I think it's hard to say that any of the other cases that the FTC has brought seeking disgorgement in antitrust cases are an overreach. They are all they all involved egregious conduct. In the pharma case, it's very easy to know exactly what happens when you delay generic competition. It's easy to figure out, relatively speaking. It's, the parties actually generally have done the calculation for you. As I said, don't have anything to say on the consumer protection side. But I think on the competition side, like if you're, setting Cardinal aside, that's one case in, 2 decades. And that it's not that they're doing it in every single conduct case. So, I just think I would disagree with you about the use of disgorgement on the antitrust side.
Michael, I think that's a fair point, but I think the challenge is the commission has given no guidance about when it will decide to use it, right? Even in competition cases. And I think that undermined its ability to continue to have that power. So, but I agree that, because I did support it in several competition cases, but Cardinal, I thought it was inappropriate.
Well, I wanted to ask. Oh, I'm sorry. Go ahead.
Yeah, no, but the commission has hurt itself, money or not, in that argument by the biggest competition case in each of the last 2 administrations they filed in federal court, which undercut the idea of the independent importance of the FTC and of the Part 3 process. I'm talking about Qualcomm and Facebook.
I wanted to just switch gears for 1 minute, ask a different line of questions, and that is, Justice Breyer made a comment about, hey, rightly or wrongly, this statute's been interpreted a certain way for 50 years, and shouldn't we just leave well enough alone? Whether it's rightly decided or wrongly decided, it's been decided, so let's just keep, deciding it the same way. And I wanted to get this panel's reaction to that comment, but also, does that have certain implications for things like the baseball exemption, which has been, routinely criticized, but is kept as a historical nicety? I just wanted to ask that question for the panel, and then we can proceed to wrap up after that. So I just wanted to pose that. What were your guys' reactions to that comment about this is the way it's been for 50 years, so should we just leave well enough alone?
Well, it's been 40 years, but the question is, what has been this way for 40 years, and what has been this way for 40 years, and that's what his later comments talked about, has been the attack on fraudsters, and we ended our recent article by saying these. The current controversy, especially this textualist argument, which again was not the dominant point, and Kavanaugh's point about textualism could just as easily have been about the text of Section 19, not the meaning of the word injunction, which was not raised. But we ended our article by saying, for 40 years, there's been this consistent interpretation blessed by 8 circuits, all in fraud cases. That's what the consistency is. It's only been very recently, and again, that's Maureen's excellent point, that the commission has branched out. And if that is consistent with the statutory structure, and I think it is, because you can't use Section 19, although Section 19 does have its use in some places. And while I was chairman and bureau director, we used Section 19 a few times. We also used Section 13B in answer to another question without seeking money. But that that consistency is there. I think it fits within the statutory structure, and I hope, although that argument was one the Commission avoided in this seeking this home run, but I hope that the court pays some attention to it.
Okay. All right, so I wanted to end this podcast kind of John McLaughlin style and just go around the horn. Each of you can give your final thoughts. So I guess in no particular order. Maureen, why don't we start with you, and then we can move around the horn.
So my thoughts are, I think this case is a very good example of what can happen when you try to push things too far, right? You take a kind of a good thing and then you try to sort of expand it, and you might end up worse off. I certainly hope the Commission, should it not succeed in this case, and my reading of the tea leaves suggests the court didn't seem very, I felt there were more votes against the FTC than there were for the FTC here. But that Congress I do think the FTC's role in fighting fraud is essential. I think it's really important. I think the ability to go into federal court and to stop, fraudulent conduct and to get true redress into the hands of consumers, restitution, is a good power. And I would hope that Congress would see fit to give it to the FTC. But I do also think the Commission needs to use its Part 3 authority more, particularly on the antitrust side. I think that is one of the reasons the Commission exists. And I have worried and continue to worry about the lure of money moving the Commission away from that route. And I think that was unfortunate.
Okay, thank you. And Tim, moving to you.
Yes, it's clear. I have a longstanding argument and a stake in the issues here, but I want to just conclude by the discussion of Congress here and the many people I've talked to in the business community supported the never position. I think gambling that Congress wouldn't do anything. Which I think is particularly after the elections in Georgia is going to be quite a gamble. Even without Georgia, the new statute affecting the SEC is applied retroactively, and it gives the SEC greater authority. Something like that is quite possible for the FTC, especially if the never side that you can never use 13B prevails. And I think that was unwise, narrow vision on the part of the business community.
Okay, thank you. And Michael, final thoughts?
So I guess maybe following up on a little bit what Tim said, I do think, I think the practical implications, I know we didn't talk a lot about those, but if the never side wins, and I don't, regardless of what I think the right answer is, I don't necessarily disagree with Maureen's reading of the tea leaves of what will happen. But if the never side wins, I think the FTC on both the consumer protection side and particularly on pharma antitrust enforcement, where it's been most successful, will come to a grinding halt, and lots of resources will be wasted. And there will be a lot more anti-competitive and fraudulent activity in the economy, and that this could go down as one of the most significant, harmful, just as a matter of policy, separate from the law, one of the worst decisions for American consumers, of this era. Okay,
and John.
Yeah, I thought that Mr. Patillo presented a very strong case. I also think he had the easier hand. He made the case that you can't reconcile an expansive interpretation of 13B with the rest of the enacting legislation, and I think that really is going to decide the issue. And He made the point that it can't be right that the FTC can get all the injunctions and monetary relief it wants without the burdens of the administrative processes that were its very reason for being. That was a compelling point. And I could tell you as someone who practices in this area, represents consumer protection clients before the commission, there really has been an overemphasis on dollars in recent years. And in my opinion, it has warped the process, and it has done it in a way that really hasn't served the agency. It hasn't served competition. It hasn't served consumers. I think Commissioner Wilson has made some thoughtful comments about the importance of non-monetary remedies lately. And I'm hopeful that we're going to see a little bit more discussion on non-monetary remedies and how that they can help consumers, and that there won't be this rush to litigate. I mean, right now, I think that there are somewhere around 70 cases that are 13B cases that are being litigated, and that is a drain on resources. It's time consuming, and again, ultimately, I don't think it serves anyone. So, I'm really interested to see how it all shakes out. But I would like to see, as Maureen pointed out, a little bit more use of the Part 3 process, and I think that would be good for everybody.
All right. Well, those are the final thoughts. And on behalf of the ABA section of Antitrust Law, I just wanted to thank each of you very much for your time today and for your thoughtful comments. And with that, John Roberti, back to you. Thank you very much.
Very, very interesting panel. Thank you, Joe. Look, Honora, let's talk about the takeaways. What's your takeaway from this panel?
My takeaway is that this panel is really concerned with the practical impact on FTC's practices, including its litigation strategy, which is something that's entirely missed in our argument, which is not something that the court is concerned with or should be concerned with. So I do think this panel gets deeper in what the FTC does or should do. So very, very good panel.
Nora, I think I had a couple of takeaways. One is, it seems the panel is sort of in agreement that this argument did not go well for the FTC, and that there will be some limitations on 13B going forward. What they are, I think, is not clear, and I think that really came out from the panel discussion as well. The idea of talking about the middle ground and perhaps former Chairman Ohlhausen suggesting there was some overreach here. All very interesting stuff, but I don't know that necessarily charts the path forward. I thought that Michael Kades' view on the likelihood of legislation was interesting as well. He is, despite his humbleness on that, he knows a lot about how Congress works. Okay, and his saying that, I'm not sure how likely it is, again, suggests that may not be the path forward. I also take, again, referring to Mike Kades, I take his comment about the importance of this ruling. I take that very seriously. With the current administration coming in, I think people like Mike Kades, who works for a progressive organization, are going to be very influential. And his views on this case, I think, are going to be very important. So I think the takeaway is, this looks like there's some change coming from the FTC, but watch this space. We're not really sure where things go from here.
Yeah, I agree.
Listen, fascinating issue today. If you are interested in learning more about disgorgement and the FTC enforcement, a couple places I would suggest. One is check out the Antitrust Source. Tim Muris has an article in there with a couple of co-authors, talks about his middle ground case. Look at Antitrust Magazine as well, has an article by Greg Lueb and a couple of other authors that talk about the impact on the antitrust world. And I think there are more articles to come there as well. I'd also suggest you take a look at the Federal Civil Enforcement Committee and Consumer Protection Committee pages. They are also going to be following this issue very closely. And watch this space. We'll also continue to update you on our Curious Amalgam. All right, well, thanks for joining. We will see you next time on our Curious Amalgam.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.